So to proceed on to our next topic, we will have here the third kind of credit transactions, which is guarantee. So what is guarantee? Article 2047 provides that by guarantee, a person called the guarantor binds himself to the creditor to fulfill the obligation of the principal debtor in case the latter should fail to do so. If a person binds himself solidarily with the principal debtor, the provisions of Section 4, Chapter 3 of this book shall be observed. In such case, the contract is called suretyship. So, if the obligation is not solidary, the obligation is governed by guarantee. But if the person who binds to fulfill himself the obligation of the principal debtor solidarily, the obligation or the contract is called suretyship. So what is the characteristics of a guarantee? Guarantee is accessory because it is dependent for its existence upon the principal obligation. So there must be a principal obligation secured by the contract of guarantee. Second, it is subsidiary because it takes effect only when the principal debtor fails in his obligation. And it is unilateral because it gives rise only to the duty on the part of the guarantor in relation to the creditor and not vice versa. And the contract of guarantee may be entered into without the intervention of the principal debtor or even without the consent of the principal debtor. So what are the classifications of guarantee? In a broad sense, guarantee is maybe personal or it may be real. Personal guarantee refers to guarantee properly so-called as guarantee in the strict sense. Here, the guarantee is the credit given by the person who guarantees the fulfillment of the principal obligation. Or, in its broad sense, guarantee may also be real when the guarantee is property, movable or immovable. So it may be when the guarantee involves property, it may be if it involves immovable property, the contract may be the credit transaction may be real mortgage or anti-crisis. And if it involves immovable property, the form in the form of it is in the form of pledge or chattel mortgage. So guarantee in its broad sense is personal or real. So with regard to the specific topic of guarantee, this topic is under personal guarantee because it refers to the um, credit given by the person. So the person binds himself to the creditor to fulfill the obligation of the principal debtor. It is not the property that was used to secure the obligation of the principal, but it is the guarantee or the credit of the person. So it is personal guarantee. So what we'll be discussing here is on personal guarantee. And if that person binds himself solidarily, the contract is suretyship. So guarantee distinguished from suretyship, a guarantor and surety are alike in that each promises to answer for the death, default, or miscarriage of another. The distinction between a guarantor and a surety are as follows. So the guarantor and surety are unlike in that surety assumes liability as a regular party to the undertaking, while the liability of the guarantor depends upon an independent agreement to pay the obligation if primary debtor or principal debtor fails to pay. The guarantor is secondarily liable or subsidiarily liable, while in suretyship, the person is primarily liable. So it would then follow that while a surety undertakes to pay if the principal does not pay, while in guarantor, he will be bound if the principal cannot pay. So in suretyship, the principal does not pay, while in guarantee, the principal debtor cannot pay. So Article 2048, a guarantee is gratuitous unless there is stipulation to the contrary. So as a general rule, it is gratuitous unless there's a stipulation that it is for compensation. Can a married woman be a guarantor? Article 2049 provides that a married woman may guarantee an obligation without the husband's consent, but shall not thereby bind the community or conjugal partnership except in cases provided by law. So a married woman who acts as guarantor ordinarily binds only her separate property. But if it can be proven that um, being the guarantor, it redounds to the benefit of the family. So the community property or conjugal partnership will be held liable or will be bound. So that is the only exception if only it redounds to the benefit of the family. But if it does not redound to it has not redounded to the benefit of the family, the community property or the conjugal property of the spouses will not be bound. So the married woman, if he will be answerable in case the principal debtor cannot pay, um, only the separate and exclusive property of that of the wife will be answerable to the said obligation. Article 2050, if a guarantee is entered into without the knowledge or consent or against the will of the principal debtor, the provisions of Articles 1236 and 1237 shall apply. Basically, guarantee is unilateral. It exists for the benefit of the creditor and not for the benefit of the principal debtor. Therefore, the creditor has every right to take all the steps to secure the payment of his credit. So if there is someone, a third person, who would like to guarantee the said obligation, maybe for gratuitously or for a consideration, um, the creditor may freely enter into a contract with that third person, notwithstanding um, notwithstanding the opposition or objection of the principal debtor. Only that if it, if it, the creditor contracted with the third person as the guarantor against the will of the principal debtor, the latter cannot be subrogated, or the third person cannot be subrogated to the other rights of the creditor. So he is only confined to ask for reimbursement of the amount of the principal obligation. So other rights that may be exercised by the creditor will not that said person will not be subrogated. Like for example, it cannot be subrogated arising from mortgage, guarantee, or penalty. Article 2051, a guarantee may be conventional, legal, or judicial, gratuitous, or by onerous title. It may also be constituted not only in favor of the principal debtor, but also in favor of the other guarantor, with the latter consent, or without his knowledge, or even over his objection. So a guarantor, it may also be constituted by in favor of the guarantor. So even without the consent or the objection of the latter. So it means double guarantee, or one constituted to guarantee the obligation of the guarantee. Necessity of valid principal obligation. Article 2052 provides that a guarantee cannot exist without a valid obligation. Nevertheless, a guarantee may be constituted to guarantee the performance of a voidable or an unenforceable contract. It may also guarantee a natural obligation. So it presupposes that you can guarantee a valid obligation or a voidable obligation or an obligation which is unenforceable, but not to avoid obligation. So if the obligation is not valid from the beginning or it is void, there is also consequently the guarantee, which is an accessory contract, subsidiary contract, is also void. But if what is being secured by a guarantee is avoidable or an unenforceable contract, the contract of guarantee will remain valid as long as the principal obligation is also valid until it is annulled. Article 2053, a guarantee may also be given as security for future debts, the amount of which is not yet known. There can be no claim against the guarantor until the debt is liquidated. A conditional obligation may be also secured. So, as I said, this is just a secondary contract, accessory contract. If the main contract has already been entered into, let's say the subject matter is a future debt. So in that contract, you may execute another contract of guarantee to secure the said future debts. So therefore, it can be used as security for future debts. Only that you cannot claim against the guarantor until the debt in the principal obligation is liquidated. A conditional obligation may also be secured. Conditional, those obligation with a period or obligation with a condition. Or resolutory obligation can also be secured by a contract of guarantee. Article 2054. A guarantor's liability cannot exceed principal obligation. A guarantor may bind himself for less, but not for more than the principal debtor, both as regards the amount and the onerous nature of the conditions. Should he have bound himself for more, his obligation shall be reduced to the limits of that of the debtor. Even if the guarantor have bound himself for more, that obligation of the guarantor shall be reduced to the limits of that of the debtor. So what is only it is only limited to the principal or the main obligation of the principal debtor. The guarantor cannot be held answerable in excess to that principal amount. Article 2055, a guarantee is not presumed. It must be expressed and cannot extend to more than what is stipulated therein. If it be simple or indefinite, it shall comprise not only the principal obligation, but also all its accessories, including the judicial costs, provided with respect to the latter, that the guarantor shall only be liable for those costs incurred after he has been judicially required to pay. So this article provides that a guarantor is not presumed, so it must be expressed. There's no such thing as implied guarantee. And it is only limited to as to the period stipulated by the parties. However, if there is no period stipulated, or if it be simple or indefinite, so the liability of the guarantor is not only pertains to the principal obligation, as well as he will also be liable to secure its accessories, including the judicial cost. So These are the liabilities of the guarantor in if it was agreed to exist for an indefinite period of time. Guarantor's liability were guarantee indefinite or simple. So if the terms of the contract of guarantee do not specify in clear and express manner that the liability of the guarantor is limited to the principal obligation in whole or in part, extends not only to the said principal obligation, but also to all its accessories, they being comprehended within the principal. What are the qualifications of a guarantor? Since it is a personal contract, you have to consider, take note of the qualifications of a guarantor. Article 2056, one who is obliged to furnish a guarantor shall present a person who possess integrity, capacity to bind himself, and sufficient property to answer for the obligation which he guarantees. The guarantor shall be subject to the jurisdiction of the court of the place where this obligation is to be complied with. If the guarantor should be convicted in the first instance of a crime involving dishonesty or should become insolvent, the creditor may demand another who has all the qualifications required in the preceding article. The case is accepted where the creditor has required and stipulated the specified person should be the guarantor. So again, the qualifications of guarantor are: first, he must possess integrity. Second, he has capacity to bind himself, and he has sufficient property to answer for the liability. So it is evident that the guarantor without the above mentioned qualifications would be useless. Of course, creditor can waive the requirements. The creditor can waive this qualification. So if he designated a particular person, notwithstanding the fact that that person does not possess all these qualifications, it will be considered as a valid designation. But if the guarantor should be convicted in first instance involving dishonesty, or should the guarantor become insolvent, the creditor may demand another who has all the qualifications required in the preceding article, except when the creditor has required and stipulated that a specified person should be a guarantor. So mangita another person who possess those qualifications, except when he specifically appoint another person to be a guarantor. So to proceed to the next chapter, effects of guarantee. So what are the effects of guarantee between the guarantor and the creditor? So the guarantor is entitled to benefit of exclusion or exhaustion. Article 2058, the guarantor cannot be compelled to pay the creditor unless the latter has exhausted all the property of the debtor and has resorted to all the legal remedies against the debtor. So the creditor has to exhaust all the property of the debtor. It is only upon the insolvency of if the principal debtor has no property, and after resorting to all other legal remedies, the creditor can go against the guarantor. So meaning the guarantor is only subsidiarily liable, not primarily liable in case the principal debtor cannot pay his obligation. Article 2059. However, that benefit of exclusion or exhausting the property of the principal debtor before going to or making the guarantor liable, this exclusion shall not take effect. Number one, if the guarantor has expressly renounced it. So if it was specifically stated in their contract that the guarantor agreed or has renounced the right or the benefit of exclusion, so the prior 2058 will not be applied. if he has bound himself solidarily with the debtor, so he will become a surety because he bound himself solidarily liable. So no need to expose the property of the principal debtor. Number 3, in case of insolvency of the debtor. Number 4, when he has absconded or the principal debtor absconded or cannot be sued within the Philippines unless he has left manager or representative. Number 5, if it may be presumed that an execution on the property of the principal debtor would not result in satisfaction of the obligation. So these are the exceptions to the benefit of exclusion. So if the debtor abscond or cannot be sued locally, the creditor is not required to go after the debtor who is hiding or cannot be sued in court. And to resort to all other legal remedies are useless. If such judicial action, including execution, would not satisfy the obligation, the guarantor can no longer require the creditor to resort to all such legal remedies against the debtor, as the same would be useless or formality. So to proceed, Article 2060 and 61. So it will be the duty of the guarantor to set up the benefit of exclusion. So in order that the guarantor may make use of the benefit of exclusion, he must set it up against the creditor upon the latter's demand for payment from him, and point out to the creditor available property of the debtor within the Philippine territory sufficient to cover the amount of the debt. And the guarantor having fulfilled all the conditions required in the preceding article, the creditor who is negligent in his exhausting the property pointed out shall suffer the loss to the extent of the said property for the insolvency of the debtor resulting from such negligence. So it will be the guarantor who must set up or who must raise the defense of the benefit of exclusion. So he must bring it up that the creditor should first exhaust the property of the principal debtor and not just raising that defense. He must also point out to the creditor what are the available properties of the debtor within the Philippine territory. So he will point out to the creditor what are those. Aside from raising the defense of benefit of exclusion, he must identify also and point out what are those properties of the principal debtor within the Philippine territory that may answer his liability, or that is sufficient to cover the amount of the debt. And after pointing that out, if the creditor is negligent in exhausting those property pointed out by the guarantor, or if subsequently the principal debtor becomes insolvent due to the negligence of the creditor, the latter will suffer the loss. So as to the procedure when creditor sues, 2062, in every action by the creditor which must be against the principal debtor alone, except in cases mentioned in Article 2059, the former shall ask the court to notify the guarantor of the action. The guarantor of the action, the guarantor may appear so that he may, if he so desire, set up such defense as are guaranteed him by law. The benefit of exclusion mentioned in Article 2059 shall always be unimpaired, even if judgment should be rendered against the principal debtor and the guarantor in case of appearance by the latter. So even if there is already a final decision rendered by the court, the benefit of exclusion, when the said decision of the court is being executed, the guarantor should always have, for his right to the his benefit of exclusion under Article 2058 shall always be unimpaired, or he can still raise that defense. or while the case is still pending, the creditor may ask the court to notify the guarantor of about the said action so that as early the guarantor could defend himself and raise the said defenses, especially this benefit of exclusion. So effects of compromise between creditor and principal debtor. A compromise between the creditor and the principal debtor benefits the guarantor but does not prejudice him. That which is entered into between the guarantor and the creditor benefits but does not prejudice the principal debtor. So if there is a compromise agreement between the principal and creditor, that agreement should not be to the prejudice of the guarantor, or vice versa, should not be to the prejudice of the principal debtor if it is entered into by the creditor and guarantor. A contract binds only the parties thereto and not to third person. Hence, a compromise cannot prejudice the guarantor or the debtor, as the case may be, when it's not a party to the compromise. Article 2064, the guarantor of a guarantor or double guarantee shall enjoy the benefit of exclusion both with respect to the guarantor and to the principal debtor. So with regard to the second guarantor, in case of double guarantee, that second guarantor may raise the benefit of exclusion with regard to the property of the principal debtor and also with regard to the property of the first guarantor. Article 2065, benefit of decision among several guarantors. So should there be several guarantors of only one debtor and for the same debt, the obligation to answer for the same is divided among all. The creditor cannot claim from the guarantors except the shares which they are respectively bound to pay unless solidarity has been expressly stipulated. The benefit of division against the guarantor ceases in the same cases and for the same reason as the benefit of exclusion against the principal debtor. So Article 2065 speaks of the benefit of division. So if Article 2050 speaks of the benefit of exclusion, this provision speaks of the benefit of division, wherein in case of liability, it should be divided among, if there are two or more guarantors, each of them shall only be answerable on the respective share. Liability should be divided among all of the guarantors, except when they agree that the obligation be solidary. But absence of the said solidarity liability, it is presumed to be joint liability. So it will be divided among all the guarantors. However, like the benefit of exclusion, the benefit of division is also exempted or cannot be raised as a defense as provided for or in the same instance as in Article 2059. So exceptions provided for in benefit of exclusion are also applicable in Article 2059, are also applicable under the benefit of division. And so to proceed to the next topic, we have effects of guarantee between the debtor and the guarantor. So the guarantor who pays for a debt or be indemnified by the latter. A guarantor who pays for the debtor must be indemnified by the latter. So after payment, the principal debtor should pay the guarantor the following indemnity. So first, the total amount of the debt. Second, the legal interest thereon from the time the payment was made known to the debtor, even though it did not earn interest for the creditor. Third, the expenses incurred by the guarantor after having notified the debtor that payment had been demanded of him, and lastly, damages if they are due. So these are the indemnities that must be paid by the principal debtor to the guarantor. When, however, a guarantee is constituted without the knowledge or against the will of the principal debtor, the guarantor can recover only insofar as the payment has been beneficial to the debtor. So you can no longer ask for legal interest, expenses incurred, or damages. So if you are a guarantor by objection or without the consent of the principal debtor, you can only claim payment insofar as beneficial to the debtor. Article 2067, the guarantor's right to subrogation. So the guarantor who pays is subrogated by virtue thereof to all the rights which the creditor had against the debtor. If the guarantor has compromised with the creditor, he cannot demand of the debtor more than what he had really paid. So he will be subrogated. That is when the guarantor is appointed with the knowledge of the and consent or knowledge of the and without objection by the principal debtor. So the guarantor will be subrogated with all the rights pertaining to the creditor. Effect of payment by guarantor without notice to debtor. So if the guarantor should pay without notifying the debtor, the latter may enforce against him all the defenses which he could have set up against the creditor at the time the payment was made. So again, as I said, when the guarantor pays the obligation without notifying the debtor, so he can have all the defenses, he can set it up against the said principal debtor. And the latter also can set up all the defense that he may have against the creditor. Thus, if the debtor has already paid the creditor, when the guarantor pays, the debtor can set up against the debtor the defense of previous extinguishment or the obligation has already extinguished by payment. The guarantor cannot be allowed through his own fault or negligence to prejudice the rights or interests of the debtor. So the debtor can use or set up all the defenses he may have against the creditor now against the guarantor. So what is the effect of payment by guarantor before or after maturity? Article 2069 provides that if the debt was for a period and the guarantor paid it before it became due, he cannot demand reimbursement of the debtor until the expiration of the period unless the payment has been ratified by the debtor. Effect of repeat payment by the debtor. So, if the guarantor has paid without notifying the debtor and the latter, not being aware of the payment, repeats the payment, the former or the guarantor has no remedy whatever against the debtor, but only against the creditor. Nevertheless, in case of a gratuitous guarantee, if the guarantor was prevented by fortuitous event from advising the debtor of the payment, and the creditor becomes insolvent, so these are the two instances when the debtor shall reimburse the guarantor for the amount that he paid. But um, as a general rule, if there is a repetition of payment, without this last circumstance, the guarantor can go after the creditor. His remedy is against the creditor. Article 2071, the guarantor, even before having paid, may proceed against the principal debtor. So even before the guarantor paid the obligation of the principal debtor, he may proceed against the principal debtor under Article 2071. Under these instances, first, when he is sued for the payment, so when the guarantor is being sued for payment, he can now proceed to also proceed um, against the principal debtor. In case number two, in case of insolvency of the principal debtor, so pending payment, uh, the 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 principal debtor becomes insolvent. So even before having paid, the guarantor may proceed against the principal debtor. And the third instance, when the debtor has bound himself to relieve him from the guarantee within specified period and this period has expired. And number five, after the lapse of 10 years, when the principal obligation has no fixed period for its maturity unless it be of such nature that it cannot be extinguished except within period longer than 10 years, because the prescriptive period regarding written contracts is 10 years. Six, if there are reasonable grounds to fear that the principal debtor intends to abscond. And lastly, if the principal debtor is in imminent danger of becoming insolvent. So Mir need not be actually insolvent. So imminent danger of becoming insolvent would be a sufficient ground for the guarantor to proceed against the principal debtor. In all these cases, the action of the guarantor is to obtain release from the guarantee or to demand security that shall protect him from any proceedings by the creditor and from the danger of insolvency of the debtor. So what could the guarantor ask for? Cannot ask for indemnity because this remedy is before he made payment on the principal obligation. So what he could ask is he should take an action to obtain release from the guarantee or to demand security to protect him from any proceedings by the creditor. Article 2072, if one of the if one at the request of another becomes a guarantor for the debt of a third person who is not present, the guarantor who satisfies the debt may sue either the person so requesting or the debtor for reimbursement. So guarantor of a third person at the request of another. So he becomes a guarantor for the debt of a third person at the request of another. So if he satisfies the principal obligation, he may sue the person who requested or the person who made the request for him to become the guarantor or the debtor for reimbursement. So he may go either of these um, persons. So what are the effects of guarantee as between co-guarantors? So Article 2073 provides that where there are two or more guarantors of the same debtor and for the same debt, and one among them who has paid may demand of each of the others the share which is proportionally owing from him. If any of the guarantors should be insolvent, his share shall be borne by the others, including the payer, in the same proportion. The provisions of this article shall not be applicable unless the payment has been made by virtue of judicial order or unless the principal debtor is insolvent. So if there are two or more guarantors for the same debtor and for the same debt, and one of the guarantors made a payment of the principal obligation. So he will ask reimbursement from co-guarantors, but it should be in proportion to their respective shares. So the guarantor who paid has also its proportionate share. So say for instance, the principal obligation is 900,000 pesos, and there are three guarantors. So the one who paid the entire 900,000 will ask reimbursement, let's say from A, 300,000 pesos, from B, 300,000 pesos, because he is also liable for another 300,000 pesos as his proportionate share. So he cannot demand the entire 900,000 or the entire 600,000 from one of the co-guarantors. It must be only proportionate to their proportionately owing by the said guarantor. So we call this right as the right to contribution of guarantor who pays. Article 2074, defenses available to co-guarantors. So what are defenses available for them? In the case of the preceding article, the co-guarantors may set up against the one who paid the same defenses which would have pertained to the principal debtor against the creditor, and which are not purely personal to the debtor. So whatever defenses that the principal debtor could have raised against the creditor, it can also be raised as a defense by his co-guarantors. Like for example, when the obligation has already prescribed, but the said co-guarantor has paid. So the co-guarantors can use that as a defense because there's no longer legal obligation on the part of the debtor to pay the debt, because the debt is already prescribed. So there is no more legal liability on the part of the debtor, but the said co-guarantor voluntarily paid. So that defense of prescription can be used by the other co-guarantor to relieve them from the obligation. So other defenses which the principal debtor could have raised against the creditor can also be raised by the co-guarantors against the guarantor who made the payment. Article 2075, a sub-guarantor in case of the insolvency of the guarantor for whom he bound himself is responsible to the co-guarantor to the same terms as the guarantor. So he is responsible to the co-guarantor. So if the guarantor of the sub-guarantor becomes insolvent, he is also liable with regard to the co-guarantors of the first guarantor whom he derived his obligation. So the liability of the guarantor will become the liability of the co-guarantor. So we are now on the extinguishment of guarantee. The obligation of the guarantor is extinguished at the same time as that of the debtor, and for the same causes of all other obligations. So guarantee being an accessory and subsidiary contract. So if the main contract has already been paid or extinguished, therefore it also extinguished the secondary or the contract of guarantee. Or if the main obligation has already been extinguished on the grounds provided for under 1231 or other causes, so like payment of or performance, loss of the thing due, condonation or remission, confusion or merger, compensation and novation, these are the modes of extinguishing a contract. So if the principal obligation has been extinguished by this mode, then the guarantee is also extinguished. Or the guarantee can also be extinguished through these modes provided in Article 1231. So Article 2077, if the creditor voluntarily accepts immovable or other property in payment of the debt, even if he should afterwards lose the same through eviction, the guarantor is released. So if the guarantor agreed, voluntarily accepted the immovable or other property paid by paid, so even if subsequently those properties or the creditor uh, was evicted or will be evicted, um, in those properties paid by the debtor, the guarantor is released, or the personal obligation of the guarantor is already extinguished after the creditor received those properties as payment of the principal obligation. Article 2078, a release made by the creditor in favor of one of the guarantors without the consent of the others benefits all to the extent of the share of the guarantor to whom it has been guaranteed. So if there are two or more guarantors and one of the guarantors has been um, released by the creditor, so it will benefit all the guarantors with respect to that portion of that guarantor. And the guarantor who has been released by the creditor would still be liable with respect to the proportionate share of the other co-guarantors. So it will be divided among all because the release will be for the benefit of all of the co-guarantors. Article 2081, the guarantor may set up against the creditor all the defenses which pertain to the principal debtor and are inherent in the debt, but not those that are purely personal to the debtor. So this article provides for defenses that may be interposed by the guarantor as against the creditor. Because whatever defenses that the debtor can use against the creditor, it can also be used by the guarantor. Inasmuch as the guarantor against whom the creditor seeks payment takes the place of the debtor, it would be absurd and unjust to deny him the defenses of the latter because the guarantor who is only subsidiarily liable would be put in worse position than the debtor, the one principally liable. So the last topic on guarantee is about legal and judicial bonds. Article 2082 provides that the bonds who is to be offered in virtue of the provisions of law or of judicial order shall have the qualifications prescribed in Article 2056 and special laws. And a bond then required by law is commonly understood to mean as an undertaking that is sufficiently secured, not for cash or currency. So it is offered in virtue of the provisions of law or judicial order. Article 2083, if the person bound to give bond in the cases of the preceding article should not be able to do so, a pledge mortgage considered sufficient to cover his obligation shall be admitted in lieu thereof. So if the bondsman, the person who is personally liable cannot be able to do so. So if you cannot secure that personal obligation, you go to the in lieu thereof. Another security is real property, movable or immovable. So you can secure the obligation through property, maybe movable, like for example, pledge or mortgage, which is considered sufficient to cover his obligation, and it will be admitted in lieu of the um, security made by the bondsman. Article 2084. A judicial bondsman cannot demand the exhaustion of the property of the principal debtor. A subsurety in the same case cannot demand exhaustion of the property of the debtor or of the surety. So judicial bondsman and subsurety are not entitled to the benefit of exclusion because they are not mere guarantors but sureties whose liability is primary and solidary. So These are all about the topic guarantee.